Hello. This presentation concerns Chapter 2 of Paralegals in the Legal System is the title of the chapter, and it is from the textbook Introduction to Paralegal Studies, A Critical Thinking Approach. The 5th edition is the edition that I'll be referring to during this presentation. First of all, my usual warning, remember that this presentation is intended to outline the textbook in your reading, and don't rely on this entirely for preparing for your quizzes or exams. Paralegals in the legal system is the subject of this chapter, and here's a quote from Justice William J. Brennan, Jr. His quote is, "Paralegals are capable of carrying out many tasks under the supervision of an attorney that might otherwise be performed by a lawyer." Justice Brennan was an Associate Justice of the United States Supreme Court, and he was in office at the United States Supreme Court from October 15th, 1956 to July 20th, 1990. He was nominated by President Dwight D. Eisenhower, and he came from New Jersey in the beginning. That's where he began his career as a judge. This chapter covers the points illustrated on this slide. We're going to define what a paralegal is. We're going to go over the types of education available for persons who want to become a paralegal. We're also going to review and evaluate a little bit of information about the paralegal professional associations, and importantly, the point of registration, certification, and licensure is essential to understand within the paralegal profession. In addition, it's important to understand what paralegals do and where they work. Traditional paralegals. Traditional paralegals are defined, traditional paralegals are typically the type of paralegal that this book explains are working in law firms. But we're also going to find out from further reading in the textbook that there are paralegals that work in different types of environments, and often they are also considered in the traditional realm of paralegals. But let's first look at the American Bar Association paralegal definition. First of all, whenever you see ABA in the legal profession, we're referring to the American Bar Association. The American Bar Association is a nationwide organization. It's a professional organization for attorneys. It is a voluntary membership organization, and as such, there is no required membership in the American Bar Association. But as the American Bar Association typically does, they provide a lot of information to attorneys nationwide and to organizations that help attorneys, and as a result they have a significant interest in the paralegal profession. And so what they have done is defined what a paralegal is. The American Bar Association definition of a paralegal is a person that's qualified by education, training, or work experience. And I highlight that word or underline that word "or" because "or" and the word "or" versus the word "and" have different meanings. And so as a result, the American Bar Association believes that training can be achieved for paralegals in either an educational environment, a training environment, or a work experience environment. The traditional paralegal, according to the American Bar Association, is a person who's employed or retained by a lawyer, law office, corporation, governmental agency, or other entity, and who performs specifically delegated substantive legal work. and for which this is for which a lawyer is responsible. So take a minute to look at these 4 points about the American Bar Association paralegal definition and recognize how, first of all, the American Bar Association defines qualifications and where paralegals work according to the American Bar Association, and notice that they performed specifically delegated substantive legal work that a lawyer is responsible for. In addition to the American Bar Association, another organization that comes into the discussion about paralegals is NALA. That's the acronym for National Association of Legal Assistants. National Association of Legal Assistants has been around for many, many years, and they are an organization that is nationwide that serves that serves people who are paralegals. And paralegals join as members of the NALA, National Association of Legal Assistants. NALA also has a definition of the paralegal profession. NALA describes the paralegal as a person who is a distinguishable group of non-lawyers, and they assist attorneys in the delivery of legal services, and through formal education, training, and experience, so they use the word and instead of or, they have knowledge and expertise regarding the legal system, which qualify them, that knowledge and expertise, qualify them to do work of a legal nature under the supervision of an attorney. So we see some similarities, that the American Bar Association does believe that in education, training, or experience for the American Bar Association, that knowledge and expertise is achieved for paralegals. And they also indicate that these are non-lawyers, just like NALA. And NALA also brings about this important distinction of supervision. And we'll go into this even more. However, it's important to recognize now that supervision is a vital aspect of the paralegal profession. If you're not licensed as a lawyer, then you shouldn't be practicing law, and as a result, the lawyer should be practicing law and delegating work to the paralegal and supervising that work. In addition to the American Bar Association and NALA, there is another organization, we refer to it by its acronym as NIFPA, the National Federation of Paralegal Associations. And that NIFPA is much like NALA in that it is the umbrella organization, although it's an umbrella organization that helps other smaller statewide or region-wide membership groups. And so they set up these membership groups set up their own paralegal organization of professionals. But NIFPA oversees all of those smaller regional organizations, geographical, if you will. NIFPA has a paralegal definition. They define a paralegal as a person qualified through education, training, or work experience, and that they perform substantive legal work that's customarily performed by a lawyer, who may be retained by a lawyer, law office, governmental agency, or other entity, or that are authorized by administrative, statutory, or court authority to perform this work. This last point is something that differs a lot between the ABA definition and the NALA definition. The ABA definition and the NALA definition refer to everything that the paralegal does being done under the supervision of a lawyer. NIFPA has included with that that these persons calling themselves paralegals may be working in a law office and retained by a lawyer or law office, governmental agency, but they also at NIFPA recognize that many people call themselves paralegals who don't work in that traditional role of paralegal, and instead give their services directly to the public because they've been permitted by law to do so. In other words, I mentioned earlier, supervision is vital to the success of staying out of trouble for unauthorized practice of law, and in NIFPA's case, they recognize professionals who also work directly for the public instead of having to be supervised by lawyers. And we'll learn more about that as we move along through this presentation as well as through the course itself. So that was an example. Those 3 examples were definitions of the traditional paralegal. The person who works under the supervision of a lawyer, has the training and the experience to do substantive work, or if not working under a lawyer's supervision, will work directly for the public because they're permitted by law to do so. The other overall type of paralegal is called a freelance paralegal. Freelance paralegals are independent contractors. They are working under the supervision of an attorney, but they don't have a job, I should say. They're working more on a contract basis, as needed basis for lawyers, instead of going to work every day. Your hours are 9 to 5 or 8:30 to 5, whatever the case may be, and that employer treating that person as an employee instead of as a contractor. All right, so that's the distinction that's different. Freelance paralegals are independent contractors. They run their own business, but they work for a law firm or a corporation on an as-needed basis as a contractor and not as an employee. I've mentioned already the area of supervision of non-lawyers. There are other types of definitions of paralegals that are different from the traditional and the freelance paralegal, and these are the unsupervised non-lawyers. The unsupervised non-lawyer is referred to usually in the literature and in the textbook, for example, as legal technicians. They are referred to as legal technicians. Legal technicians are those who provide legal services, and I have highlighted that word here, services to those who represent themselves. And lay advocates represent persons before administrative agencies. And you'll learn an administrative agency is is a governmental agency, and there are a lot of examples, or there are several examples of unsupervised non-lawyers who are able to represent persons without supervision from a lawyer. All right, so legal technicians and independent paralegals, these are people who provide services to people representing themselves. All right, and lay advocate is someone who doesn't have a person representing themselves, but they are able to represent those people in an administrative agency type of environment. And there are a couple of other newer examples developing in the legislation of some states, such as Washington, where there's some limited licensure areas. But I won't jump to that yet. Let's stay as best I can with the topic. I apologize. Okay. So the next point of another type of unsupervised non-lawyer is the legal scrivener. These are, I always like to explain that there are businesses out here in Florida. It's very common in Florida to find document preparation businesses where they are actually preparing standardized legal documents They advertise to the public that they do this, and they they have a building with a sign over the door, etc. And the legal scrivener is unsupervised by a lawyer, and they have to be really careful about their activities so that they don't their activities do not appear to be practicing law. And they have to avoid calling themselves lawyers because legal scriveners are not lawyers. The document preparer is sort of synonymous with the scrivener, but they're typically limited as well in being able to prepare documents and use published factual information to make those to prepare those documents. In other words, the main goal of the unsupervised non-lawyer is to avoid practicing law or giving the appearance that they're practicing law. So when you bring into the conversation a discussion of the practice of law, it begs the question, what is the difference between a person who is a non-lawyer and a person who can practice law? Well, this slide illustrates exactly that. First of all, a paralegal is a non-lawyer. An attorney is a person licensed to practice law. These areas on the slide presentation, each of these, I'll only go through briefly. They're in your textbook, but just recognize that a paralegal is not required, as we learned from the definitions that we've seen so far, to have an undergraduate education. A bachelor's degree is required of an attorney. In order to get into law school, a bachelor degree is required. Specialization education, it's not required for the paralegal. Plus a specialized education is required for an attorney. They go to law school in order to prepare themselves for the test called the bar exam right here. And paralegals are not required in any state to take a bar exam. The license and the morals check is sometimes in some states required a morals check, but in order to practice law in most any state, you must be licensed. In all states, you must be licensed by that state. But the important point is the difference between a non-lawyer and an attorney is the licensure. And the state is, each state has a licensing criteria. And as you can see, attorneys have advanced degrees in terms of the law school, and they have to pass the bar exam. So eventually they are licensed, unlike paralegals who are not. Qualifications. Well, now we come to the point of where we describe for you, I help describe for you what is an effective paralegal. And there are a few things that the book points out are the most effective qualities and qualifications needed to become a paralegal. Well, first of all, paralegals need to have a sound grasp of substantive and procedural law. Substantive law is the law is the law that explains what our rights are, or what our rights are among people. Substantive areas of law are unlike procedural law, where procedural law describes the way the law works, the technicalities of the law. For example, a substantive area of law would be family law. Procedural law would be how the court system works. Next area that's discussed in our textbook is that paralegals, to be well qualified for the position, a paralegal needs to be able to think analytically and logically, and be able to analyze facts and compare the facts with the law and come to a conclusion that's logical based upon the facts and the rule of law. This kind of reaches back to Chapter 1, where we talked about Mr. Drake a little bit, the grandfather who witnessed his grandson in the accident that killed the grandson and brought about a heart attack on the part of Mr. Drake, the grandfather, as well as some emotional suffering. So being able to think analytically and logically is one of a few of the effective paralegal skills that are required. The next one is being able to communicate clearly and concisely. This is really, really important in terms of interpersonal communications, and as well as being able to write and describe orally findings from your research, findings for your legal research, findings from your factual background search, etc. So being able to communicate clearly and concisely is a vital skill. And back to the interpersonal types of skills, acting congenially and in a professional manner is also a very highly sought after qualification of paralegals, because of the nature of the work of working with people in an adversarial system. It's still necessary to be able to interpersonally deal with people in a congenial and professional manner. And despite the fact that paralegals, in the traditional sense, are supposed to be supervised by attorneys, paralegals are still expected to be problem solvers and know how to solve problems with minimum supervision. The work itself, of course, is always supervised by an attorney. The final word is always from the attorney. But as far as being able to accomplish the task that a paralegal does, that person needs to be a good problem solver and able to solve the types of problems encountered with minimum supervision. Another important skill or qualification of a paralegal is being able to work within deadlines. The American legal system is very deadline driven. It's so important to be able to understand the expectations the law has as far as deadlines. We do things, procedural law, for example, is one of those areas of law where it's very time sensitive. If there has been one action taken, for example, the filing of a complaint in the courthouse, and that complaint has been now served upon the defendant, there's only a 20-day span of time for the defendant to file an answer. The point is that type of scenario and every other scenario that goes on in the legal system typically has a deadline attached to it. And so it's really important to work within deadlines. And then the last one that the textbook brings about or discusses is how a paralegal has to possess ingenuity and have good judgment. When we talked about earlier in this presentation, when I talked about the areas like education and experience, remember that there are two lines of thought. One is that a person doesn't need education to become a paralegal. Others believe that a person could have education and experience. So the next part of the textbook briefly goes into what kinds of requirements need to be fulfilled by a school that's offering an educational program in paralegal studies. If there are situations or definitions and other situations where education is important, then we need to look and make sure that we have the right education. So the American Bar Association approves educational programs, and that's voluntary approval. In other words, schools are not required, paralegal programs that is, are not required to go through the American Bar Association and get approval of their program. It's totally voluntary. Approval means that the school is in compliance with areas like the faculty have certain amount of experience. The school has a library for the students that has enough materials for the students to use in legal research, and many other criteria. In addition, well, maybe not in addition, but also, since it is voluntary to be approved by ABA, some schools have chosen, of course, not to be ABA approved. And if that school is in substantial compliance with those same approval standards of the American Bar Association, that school can become a member of the American Association for Paralegal Education. We call that AFP, the acronym AFP. State College of Florida's paralegal program, for example, is not ABA approved, but we are in substantial compliance with the ABA approval standards, and so we've voluntarily become an institutional member of the American Association for Paralegal Education. Earlier in when we were talking about definitions, I mentioned a couple of these paralegal professional associations. Belonging to a professional association is a wonderful thing to do, and by the way, there are a lot of student memberships available as well. The NIFPA, National Federation of Paralegal Associations, that I mentioned earlier, they have a student membership, and they also, of course, serve professionals in the paralegal profession. And so you can become a member of NIFPA by joining one of their geographic organizations that I talked about earlier. The National Association of Legal Assistants, NALA, they have a student membership, and you'd be able to become a member under the student membership criteria, or if you're a professional already, under the professional criteria. And the Paralegal Management Association is called International Paralegal Management Association, IPMA, we call it. IPMA is another paralegal professional association. The advantages of belonging to a professional association is to have continued schooling, continuing education, I should say, in the areas that you work in the legal areas that you work in, to have a code of conduct that others in the profession are following in order to maintain some stability in the profession. Other areas that become, they have advisory panels. The National Association of Legal Assistants and NIFPA both have a certification type of exam that persons in the field can take to become certified. Okay, next, although there are paralegal professional associations, and although there is the American Bar Association, and although there are, every state has a licensure strategy, or I should say rules that lawyers follow, the effect of all of that still comes down to the fact that there is no licensure at this time for paralegals, other than in one state, the state of Washington, that has just recently, this presentation is being made on May 10th, 2014, and I believe it was late in the year of 2013 that the state of Washington began, or their legislature enacted a statute permitting a limited licensure type of paradigm for non-lawyers in Washington. So that's a state law. Florida does not have any type of licensure right now. But this slide is intended to help illustrate the levels of regulation. And when I say regulation, I mean Who is watching over the paralegals of the world, of the United States? What organization, in nurses, with nursing, with doctors, with lawyers, there's an agency that oversees the licensure and gives those persons a license, and in addition, gives oversees what that person is doing. So if someone is harmed, or they're concerned that they're working outside the boundaries of the job, or the licensure that they're given, then someone can intervene and investigate and do something. So all of that is what I mean by regulation. Who is watching over and giving the credentials that a legal assistant, or paralegal I should say, needs? Well, first level is called registration. Registration is when an individual has their name on an official list and it's voluntary. There's also the next level, which is certification, which is also voluntary, in terms of no one is saying, no one as a regulatory agency is saying you must be registered as a paralegal or you must be certified as a paralegal. And as far as the general public, including all the paralegals in Washington, there is no licensure in any state so far. So let's look at these a little bit closer. Registration, as I pointed out a minute ago, is that individuals or organizations can voluntarily have their names placed on an official list by a private organization or a governmental agency. Florida, for example, has the Florida Registered Paralegal Program. If you have, I have a separate presentation on that, but generally it is the Florida Bar developed this in 2008. They adopted a rule that permits paralegals, persons who work for lawyers, in the traditional sense, only the traditional type of paralegal that works under the supervision of lawyers, to become a registered paralegal. And the official list of the Registered Paralegal Program is kept by the Florida Bar. So this is a governmental organization, the Florida Bar Agency, that says we now have a system to put you on a list if you want to be one. And you have to meet the qualifications that they require to do that. So that's what registration is. In addition, there's certification and certificated. So I always like to make sure students understand the difference between certification and certificated. That second level of regulation is certification that's done by a non-governmental organization for meeting special criteria. I mentioned earlier in this presentation that NALA, the National Association of Legal Assistants, has a certified paralegal program where if a person is a paralegal, they can take an exam. If they pass the exam, they can give themselves the certified paralegal status. But notice that NALA is not a governmental organization. NALA is a non-governmental organization that promotes paralegals in terms of the paralegal profession. So that's what certification is. Some of you as students, though, may be coming to school at SCF to get the Advanced Technical Certificate, or the ATC. When those students finish with their Advanced Technical Certificate requirements, they'll receive a certificate and they will be certificated. And while we are a governmental school, we're a public school, so we are governmental, it is in no way a recognition by any government agency, just like certification from NALA would be. It's in no way saying that anyone's watching over you when you leave and start working. The highest level of regulation is called licensure. Lawyers, I told you earlier, they're licensed. Paralegals are not licensed. Licensure For lawyers, as I pointed out, they get a bachelor's degree, they go to law school, they study for the bar exam, they take the bar exam, they meet all the other criteria that the bar requires, and they get a license from the state bar association that says you've met those standards. So it's a process. At this time, except that one little example I gave you in Washington, there's no such thing as licensure of paralegals. And that licensure is not required in Washington unless a paralegal chooses to work in the areas where limited practice is permitted by paralegals, being non-lawyers. In other words, it's still voluntary unless you want to work in that area of the law. And so currently, other than Washington, I'll have to explain that, other than Washington, no states license paralegals or legal technicians. NALA operates a formal certification program. It's through an examination process, and it's voluntary. NIFPA administers what we call the PACE proficiency exam, and the PACE proficiency exam, like the NALA exam, says you meet the qualifications of our organization. But again, NALA and NIFPA are non-governmental. State would be governmental. All right. Once again, we have to look a lot in the area of unauthorized practice of law. We also call it UPL. That's the acronym for unauthorized practice of law. And it's just really important to bring this up as much as possible so our students remember by the time they're finished. It's one of the big three is unauthorized practice of law. And this is the reason I include this in this presentation is because in the textbook in Chapter 2, let's see if I can find that real quick. Chapter 2, there is an ethics alert, I think on page 30-something, that explains how, oh yes, here it is. On page 32 there's an ethics alert, pointing out that there are some areas that you always want to avoid as a non-lawyer. Not to commit unauthorized practice of law by giving legal advice, signing court documents, appearing in court on behalf of the client. Those are the big three: advice, signing documents, or appearing in court. In addition, paralegals have to respect the same confidentiality that the attorney has to respect. And this goes into another area that we'll spend a lot of time on, but just very simply put, when a client tells you something, you cannot tell other people what your client said. And this is part of that relationship of the attorney-client relationship, and it has to be respected by paralegals as much as by lawyers. In addition, a lawyer cannot represent people with adverse interests. The best example is husband-wife in a divorce. We can't represent both people, the lawyer can't, and the paralegal needs to aid in helping avoid that conflict. What paralegals do. Paralegals are one of the things that I've put into the course for you to look at is a video on careers in the public safety law the public safety in the law sector, which is interesting. It has a nice short little section on what paralegals do. The main areas that the textbook and that our program courses help to emphasize are that paralegals communicate with clients. They do some intake interviews after the client has hired the lawyer. They will make a lot of calling to the clients to ask them questions, find out more information, even to schedule appointments with them to come in and visit about what needs to be done next. So the paralegal is very much the right hand of the lawyer where it comes to dealing with the clients on a pretty regular basis. Paralegals do research. Paralegals research both facts. In other words, they investigate to find additional factual information, and they also do that legal research that we talked about in Chapter 1 in order to help the client, help the attorney make that analysis of the facts with the law. In addition, the paralegal will help to draft the documents that get filed with the court, or draft a letter that needs to be mailed to the opposing attorney in a case. And one of the things is case management. Sometimes I call this project management, managing the case in terms of if it goes to trial, or even if it isn't planned for trial. There's a lot of data and information and paper, be it converted to electronic means or not. There is a lot to manage in terms of deadlines, document preparation, additional legal research that needs to be done, and the communication with the clients. So case management is sort of a catch-all net of everything else. This next slide deals with explaining where paralegals work. There are a lot of different environments that a paralegal can work in, but private legal practices is where 70% of paralegals work. They work in traditional partnerships where the paralegal is not the partner, but 2 or more lawyers are partnered and doing legal services for the public, and they work in that type of business relationship where their attorneys are partners in a business. The book also goes into some of the reasons why we choose traditional partnerships. Not we, but lawyers might choose the different types of partnerships. And that's also an area that you cover more in business organizations, the course Business Organizations. Another type of legal practice entity is a professional corporation. A professional corporation is one where the it's like a corporation, but it's owned by persons who are licensed, such as lawyers and accountants and doctors. And the idea of professional corporations is to shield liability between each other, because it's important to recognize that lawyers, doctors, and accountants are in an area of work where there's a high instance, well, not a high instance, but a high there's a lot of opportunity, let's put it this way, because of the type of work they're doing, to make mistakes. So if 2 lawyers are working together and one makes the mistake and the other one's didn't make any of the mistake, had nothing to do with the problem, gave the other lawyer misguided a client, not me, it's necessary to have a protection from that liability if that happens. And professional corporations are like corporations where the lawyers own shares, and they're protected up to the amount of their investment. They're protected from liability. There are other ways to limit liability with a limited liability partnership. And I should mention that corporations and partnerships are governed heavily by state law, entirely by state law. Each state is different. In Florida, we have several different types of business practices that a person can set up, and limited liability partnerships are one of those, to limit the liability of the partners between each other. And there's a little more about it in the book to read about and understand. Sole proprietorships are not uncommon. In fact, I read that sole proprietorships for lawyers is one of the largest forms of business entity in the lawyer profession, and as a result, they really do put themselves out there for a lot of liability, because as a sole proprietorship, lawyers are not protected by only up to the amount of their investment. They have unlimited liability in terms of they have not set up a business in such a way that it protects their home and their car, their watch and their other jewelry from a client who's harmed by them to come in and take everything that they own. So again, this is all a little bit sketchy details in the textbook. I don't want to go into it a lot here because what's in the textbook is sufficient for this course. But in business organizations, when you take corporations and business organizations, it's a vital part of the lessons, and that is limiting liability. That's what I always say about business organizations. There are two things that are naturally apparent about the type of business chosen. How much liability do you want to prevent, and how much taxation do you want to prevent? Another type of business practice where paralegals might work, office sharing arrangements are very common in the legal profession. A number of lawyers will share a building and share also the receptionist or the common areas of the building in order to cut back on expenses of having, an office and a conference room and a reception area and another office for one lawyer to practice in. Instead, they have 5 offices, 5 lawyers, one in each office, one conference room, one reception area, and it's an excellent office sharing type of arrangement. In addition to the standard private practice type of arrangement, paralegals also work in settings like legal departments of businesses, and in our near area, if you can think about maybe the hospitals, they have a legal department. Manufacturers have legal departments often, and they will have a legal department in that business where paralegals will be working with that lawyer or the lawyers and other staff in that department. In addition, governmental agencies is a big area of employment. The police, the agencies also like the Environmental Protection Agency would have a need for people who have good understanding of the law. There are just tons and tons of governmental agencies where persons with paralegal experience and education can find work. Legal clinics. Legal Aid of Minnesota, for example, is a legal clinic. It's designed to help indigent persons. Its foundations are about helping indigent people with their legal needs at no cost if they qualify, if the client qualifies. And legal services offices are a lot the same. So there are different environments where a paralegal can work, and I think that in addition to what you're reading here in the textbook, there are some excellent materials that I've also provided in the online course. The movie I mentioned a few minutes ago, talking about some of the different areas in public safety and in law that people work. And there's a magazine article from Paralegal Today that I posted in the course, and there's also a couple of other things, I don't know, in the lesson that we're doing now that are intended to help you see the different places paralegals work and truly how incredibly diverse the paralegal profession is, that it's not like what we think of. Even though 70% of paralegals work in the traditional law office type of setting, there are still businesses, government agencies, clinics, and legal services offices that can capitalize from the use of paralegals or the having employed paralegals. Okay, so that is everything for this chapter, and thank you so much.